Good afternoon, sir. I'm Ms. Henrha, number 8 to answer of your final examination. Define evidence, explain scope. Revise of your evidence, rule 1 to 8, section 1, evidence defined. Evidence is the means action by these rules of ascertaining in judicial proceeding the truth respecting a matter of fact. Revise of evidence, rule 1 to 8, section 2, scope. The rules of evidence shall be the same in all courts and all trials and hearings, except as otherwise provided by the law or this rule. Number 2, what are the three kinds of evidence? Briefly explain. Revised Rules of Evidence Rule 130, Section 1, Object as Evidence. Object as evidence are those addressed to the assessment of the court. When an object is relevant to the fact and issue, it may be exhibited, examined, or reviewed by the court. In Revised Rules of Evidence Rule 130, Section 2, documentary evidence, documents as evidence consist of writings or recordings, photographs, or any material containing letters, words, sounds, numbers, figures, or symbols of the equivalent, or other modes of written expression over the proof of their contents. Revised Rule of Evidence Rule 130, Section 22, testimony confined to personal knowledge. Witness can testify on those facts, which he or she knows to be so or personal knowledge. 3. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character, tending to prove the same point. It is a piece of evidence that may be derived from various sources, but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character, tending to prove the same point. 4. What is prima facie evidence? So prima facie evidence is evidence which, if unexplained or uncontradicted, so is sufficient to sustain as judgment favor of the issue it supports. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offers the prima facie evidence. Number 5. What is dying declaration? Section 37, dying declaration of a dying person made under a consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. Number 6. What about statements uttered as part of the res gestae? Section 44, part of res gestae, statements made by the person who startling occurrence taking place or immediately prior to subsequent thereto under the stress and excitement caused by the occurrence with respect to the circumstance thereof may be given the evidence as a part of the res gestae. So also statements accompanying an equivocal act material to the issue and giving it the legal significance may be received as part of res gestae. Number 7. What is an order examination of individual witnesses? Revised Rules and Evidence Rule 132A, Section 4, Order examination of individual witnesses. The order in which the individual witnesses may be examined as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Direct examination by the proponent. And D. Cross-examination by the opponent. So Revised Rules on Evidence Rule 132A, Section 5, the direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. And the Revised Rules on Evidence Rule 132A, Section 6, cross-examination is purpose and extend upon the termination of direct examination. The witnesses may be cross-examined by the adverse party on a relevant matter with sufficient fullness of freedom and accuracy of the interest or bias. Number 14. Distinguish burden of proof, burden of evidence. Revised rules of evidence in Rule 131, Section 1. Burden of proof, burden of evidence, burden of proof is the duty of a party to present evidence of the facts in issue necessary to establish his or her claim defense by the amount of evidence required by the law. Burden of proof never shifts. Burden of evidence is the duty of party to present evidence sufficient to establish the review of fact issued to establish a prima facie case. Burden of evidence may shift from one party to another course of the proceedings depending on the exigencies of the case. 15. What is the standard proof necessary in civil cases? Revised rules on evidence through 133, Section 1, preponderance of evidence, how to determine civil cases. The party having the burden of proof must establish his or her case by preponderance of the evidence. In determining where the preponderance or superweight of evidence on the issues involved lies, the court may consider all the facts and circumstances of the case, the witness, manner of testifying, their intelligence, their means and opportunity of knowing the facts to which are testifying, the nature of facts on which the probability or the improbability of their testimony, their interest of want, and also their personal credibility. So far, the same may legitimately appear upon the trial. So the court may also consider the number of witnesses, though the preponderance necessarily with a great number. Criminal cases rules of evidence rule 133, Section 2, proof beyond reasonable doubt. In criminal case, the accused entitled to be acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt doesn't mean such a degree of proof excluding quality of error produces absolute certainty. Moral certainty only is required, or the degree of proof which produces conviction of unprejudiced mind. 16. Administrative cases, briefly define each. Revised rules of evidence in 133, Section 6, substantial evidence. In cases filed before administrative quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence or amount of relevant evidence which a reasonable mind accept as adequate to justify a conclusion. So substantial evidence is the least quantum of proof required by the rules. It is applicable of administrative actions with like judicial actions, not including conducting a full-blown trials, are meant to be concluded with greater speed. An administrative body can render a decision on the basis of the evidence presented. Is evident which is reasonable mind may accept adequate to justify a conclusion. This means that the evidence can make a reasonable person believe that the allegations have occurred. 17. Define what are the public documents. Revised on evidence rule 132, Section 19, classes of documents for the purpose of the presentation of the evidence. Documents are either public or private. A. Written official acts or records of the sovereign authority, official bodies, the tribunals, and the public officers, whether the Philippines or foreign country. B. Documents acknowledged before a notary public except last wills and testaments. C. Documents that are considered public documents under treaties and conventions which are in force between the Philippines and the country of source. D. Public records kept in the Philippines are private documents required by law to be entered therein. Number 18. How do you prove a present in the court private documents? Revised rules, evidence rule 132, Section 20, proof of private documents. Before any private document offered as authentic, received in evidence in due execution, and authenticity must prove it of the following means. A. By anyone who saw the document executed or written. B. By evidence of the genuineness of the signature of the handwriting of maker. Or C. By other evidence showing the due execution and authenticity. Any other private document need only be identified as that which is claimed to be. 19. The original document rule states that when representing document as evidence, only the original is admissible. What are the four exceptions? Then Section 3, original document must be produced. Exception. When the subject of inquiry in the context of document, no evidence shall be admissible other than the original document itself, except the following cases. A. The original has been lost or destroyed, cannot be produced in court without bad faith on the other part of the offeror. B. When the original is the custody under the control of the party against whom the evidence is offered and the latter fails to produce after reasonable notice. C. When the original consists of the numerous accounts or other documents which cannot be examined in the court without a great loss of time, the facts sought to be established from D is on the general of the whole, and D, when the original public record in the custody of a public officer is recorded or the public office. 20. Who can become a witness? Qualification of witness, Section 20. Witness, their qualification except as provided in the next succeeding section. All persons who can perceive and perceiving can make their own perception to others may be a witness. 21. When is an extrajudicial confession with the confession sufficient to sustain a conviction? In Section 3, extrajudicial confession, not sufficient ground for conviction, an extrajudicial confession made by an accused shall not be sufficient ground for a conviction unless corroborated by evidence of the corpus delicti.